Welcome to Wills, Estates, and What Comes Next, Probate Insights with Jamie Cuzmar.
Welcome to Wills, Estates, and What Comes Next, the podcast where Florida families get clear, compassionate guidance through estate planning and probate. Sophia Morales here with attorney Jamie Cuzmar, founder of the Cuzmar Law Firm. Whether you're planning ahead or navigating the legal process after losing a loved one, this show is here to make complex topics feel understandable and manageable. So let's get started on today's topic, life events and legal readiness, estate planning through every stage. Welcome, Jamie. I'm so glad to be back here talking to you again.
Thank you, Sophia. Good to see you again.
Let's start with the fundamentals. What are the key life events that should prompt somebody to review or update their estate plan or their will or their trust or whatever they have going on in that area?
Yeah, key life events, I would say, are those situations where you have other parties coming in to the mix or exiting the mix. So think of a new marriage or perhaps a divorce or a new child. Those are primarily the times you would want to consider updating or reviewing your estate plan, because if you have, say, an ex-spouse as a beneficiary somewhere, say a will, then that might, go to that person when you intended it to go to a new spouse or just to your children. It's very important to consider those things when a life change happens. So sometimes other people will want to name a different personal representative. Say they have a personal representative, like their sibling or their brother, but then that person passes away. You want to make sure you fill in the gaps in case something like that happens. That way there are no gaps in your own plan.
And just help me with the definition. What is a personal representative in Florida? Is that like an executor?
Yeah, so an executor, the term executor is one where a person passes away with no plan, and the probate court will assign an executor, similar to what a personal representative would do. So a personal representative is somebody that's named in the actual will, if there is a will. If there's no one named in the will, then the court will name an executor to fulfill the same role as a personal representative.
Okay, very good. So you mentioned when the members of your family change that you should consider thinking about this. So how does getting married or getting divorced impact the existing plan generally?
I would say getting married, of course, you probably don't have these plans to begin with. A lot of people wait to get married, but sometimes people do have a will before getting married. And so it's important to just look at things from the current situation. So planning for end of life, of course, it's only as good as what you have in place now. So as your situation changes, like getting married, maybe you don't want to add the new spouse as a personal representative. Who knows? But certainly, if you have somebody named as personal representative and you get married and you want to make the new spouse have a role, then it would require an amendment either to your will or just redrafting it altogether. And in some cases, you can amend your trust if you have a trust. And of course, in that same light, a divorce, you may or may not want to keep the ex-spouse on there. Some people do. Like, say, for example, you get divorced, but that's the only person that you can trust still. You don't have a new spouse in the picture. You're not, dating anyone. And then in the interim, maybe it's okay to leave that spouse there or the ex-spouse there. But certainly if you guys were to get divorced on bad terms, then most people don't want to have their ex-spouse any skin in the game or any kind of decision-making power for you.
Right, or anywhere close to them.
Right. There are exceptions, but yes, most of the time you want to remove them from your plan.
So if you're a new parent, what are some of the considerations that new parents have around the child and guardianship and assets?
Yeah, so guardianship is one of those things that you can elect along with your spouse if you're married to go ahead and have somebody legally raise that child. And then beyond the guardianship nomination, there's also a document that's similar, a healthcare power of attorney or healthcare surrogate for the minor, to allow that guardian to take that child to not only the doctors, but also to be able to review their medical records and make medical decisions for that child. So that is the primary set of documents, the long-term guardianship, sometimes a short-term guardian nominations. If the long-term guardians are further away, you want to maybe consider short-term guardians as well in the interim while the long-term guardians come into town, because you certainly don't want that child or children to be with strangers in the meantime. Think about Child Protective Services or the sheriff's office. They're the ones that will initially take the child if there's no short-term guardian named. Right. So I definitely suggest to families all the time to list a short-term guardian, even if it's just a nanny. And that is exactly designed to do what it says, that it's for the short term, the interim, just, for a couple of days until the long-term guardians come into play and be able to take the child more permanently. So another thing that comes into play in estate planning is considering how old your children are. You don't necessarily want to leave them everything outright if they're still minors. So one thing that a lot of parents and families don't consider is who to name as the guardianship or the trustee of the trust that's going to oversee those assets for their children. So I tell people, if you have a child that's very little, and of course, if something happened to you tomorrow, there would be, another decade involved before that child can receive those assets. It's important to consider your trustee. Some people might be better off naming a professional fiduciary or like a trust bank that's going to oversee that and handle the trust for you, right, versus an individual. Because the longer a trust lasts, that manager or that backup trustee is going to have a lot more work to do than just a simple outright distribution if the child was already an adult.
Let me ask for a little clarification here. For us uninitiated folks, what is fiduciary exactly?
So fiduciary is, off the top of my head, is somebody that is legally responsible and they'll act in place for the deceased person. So fiduciary, a step above from just like a trusted friend. A fiduciary does have some skin in the game. Legally, they're required to do things a certain way. So when it comes to trust planning, if you name a trustee, which is a type of fiduciary, they have, for example, an obligation to the client. So if you think of a trust fiduciary or a trust bank that's managing and acting in the role as trustee, so they have additional requirements. So as a fiduciary, they could be legally responsible or be held accountable or have some liability if they do things incorrectly. So think of a deceased person's trust that has assets, and the trust assets have to be managed over a significant period of time. Then those assets need to be either invested. There's going to be tax returns for the trust as well. And so it's better to have a fiduciary involved there, because one, they're professionals, and number two, if they do something incorrectly, then they'll be liable for, say, the misappropriation of funds, stuff like that.
Okay. And they probably carry some kind of insurance or bond or something as well, I would imagine.
Yes, exactly.
What estate planning steps are crucial when you're looking at assets like purchasing a home or a business or something like that?
Yeah, so when purchasing a home, one of the things that I see is a lot of times couples will purchase a home together, but for whatever reason, on the deed of the house, you'll have both parties on the note, on the loan, the mortgage, but for whatever reason, only one person makes it onto the actual deed. And so that is one thing that I would say it's crucial, especially the house being the biggest asset in most people's portfolio is the house, is to make sure that the house reflects that they're married and possibly add the spouse to that deed itself. Another step would be to transfer the house into the trust, because consider if you have a beautiful trust, it's been drafted and you've paid a pretty penny for it. If the house isn't titled or it's not in the deed of that house, if the trust does not have any tie to it somehow, then it's going to fall outside of the trust and it's going to end up in probate. So that's one thing that a lot of clients have had trust planning in the past. And just remember that some attorneys don't do the trust funding. They don't help move the assets under the control of the trust. So just be careful of that. Double check if you have a trust out there. Double check that your house has been titled to the trust. Otherwise, the house is going to go through the probate no matter what your trust says. If there's no tie to the trust, then unfortunately, it's kind of been done for nothing. So that's an important crucial step is called trust funding, and something that we provide here in our practice as well.
Can a pour over will stand instead for doing something like that, or are you kind of gambling when you do that?
Yeah, you can do a pour over will. I do provide pour over wills along with clients that do a trust. The pour over will is a contingency, so I definitely prefer my clients to move that assets under the control of the trust somehow, either through a beneficiary form, if it's like a financial account, a bank, or life insurance policy, or the house being titled to the trust ahead of time during their lifetime. The pour over will is again, it will work out, but it's a very small window of being able to use that contingency to move stuff over. So you could, of course, have your
Gotcha.
personal representative do it for you, but again, once the state catches wind that the person passed away, they're going to start locking things down. So it's very
Right.
important. Mhm.
Wow. Okay. So that brings us around to the role of beneficiary designations. What do you recommend around reviewing those when you're faced with a major life transition?
So beneficiary designations is essentially you deciding where you want your assets to end up, right? Most people, most families want their children to have their assets, but of course, if the children are still minors, that's something to maybe consider drafting it a different way, putting age requirements into a trust. So a lot of people that do a trust, that's one of the more popular features that is that you can decide when those children are able to accept those assets. Let's say you guys pass away, God forbid, and the children are still minors. You could specify that they're not supposed to get the assets anyway until they're a certain age. You can specify specifically what age, as long as it's above 18. So a really popular scheme that a lot of clients will take is they'll split it up into thirds. So say there's one direct beneficiary, the child, you can break it down to where the child gets 1/3 share of their assets, or of the trust assets at 25, the second third at 30, and the last at 35. Just so it gives them kind of those time frames, for example, coincide with 25 finishing college and having some debt of education debt to pay off, at 30 possibly buying your first home, and at 35 possibly getting married, and then getting your own plan in place for your own children, your own new family. So those years, of course, those ages are discretionary. You don't have to do that. A lot of people will say, oh, my children are already adults, so I don't have that worry. Then you can just do an outright distribution, and they'll get it immediately after you pass. And of course, your trustee managing the paperwork to pass on those assets to the beneficiaries.
Sounds like the trust is extremely helpful for that sort of thing.
Yeah, yeah. Beyond, above and beyond just a simple will, the trust definitely has way more contingencies available to the planner. So,
So, speaking of contingencies, what should we be planning for around not dying, but more like incapacity? You get really sick or you get terribly injured.
yeah. So, incapacity planning is something that you can plan for in the form of a power of attorney. There is a durable power of attorney for finances where you name somebody, most times your spouse, as the agent to act on your behalf, to make financial decisions for you, even to sell property if you wanted to add that right in that document. And then you also have what's known as a healthcare surrogate or advance directive, also known as a healthcare power of attorney, to designate somebody to make medical decisions for you in case if you can't make those decisions for yourself. It also goes along with HIPAA, so that you'll have HIPAA language included in those documents where the person you've named can review your medical records. And of course, along with the recommendations of the doctor, go ahead and play that role and make decisions for you. Again, only if you can't make them for yourself and you can't speak for yourself. So I do have a lot of people that are a little afraid to sign those documents. Say, I'm going to give those rights to somebody else to make for me. And I'll explain, well, they can't override your own wishes. As long as you're able to verbalize or write down, even if you can't speak, you can write them down, your wishes. As long as you can make your wishes known, they can't take over your whole life for that matter. It's only if you're not able or capable. Think of a stroke, for example, and you have some kind of disability, you can't even sign your name anymore. Or if you have a stroke and then you're incapacitated mentally, you're diminished mentally, where you don't even know what's going on, then that's where those documents will play a vital role. And if you didn't have them, you would have to petition the court to get those rights from the judge. So that's saves a step there as well. Similar to avoiding probate, you can avoid having to go in front of a judge to ask for those rights by having the documents done ahead of time.
Well, let me ask you something, because I know a lot of spouses are like, well, my husband will make the decisions, or my wife will handle the decisions. I don't need to do anything fancy. What is the flaw in that reasoning?
So that's a common misconception. It used to be that spouses could make those decisions for each other, but consider now that half of marriages end divorce, and now it's even ticking upwards to 60%. But now consider them not all marriages are happy ones. So a lot of times people assume that incorrectly. And there was a very famous case in the past called the Terry Schiavo case, where there was a spouse who was in a coma. The husband wanted to go ahead and remove her from artificial life support, but the parents did not. They wanted to keep her on and have her hanging on, and hopefully, in the months that followed, she would recover. But the doctors, of course, made the recommendation saying that she was basically brain dead. And so there was that conflict. And now the state of Florida requires either for someone to have a signed power of attorney and a healthcare directive to make those decisions. And the spouses are no longer able to do that just because they're married. They would either have to have the healthcare surrogate signed or go to the court and petition the judge for that approval to make those decisions.
Very good. So important document to check off.
Yeah,
And,
yeah,
and
absolutely.
if I remember what I saw in the news around the Shibo case, there was some question about the motivation of the husband on that one as well.
Yeah, sometimes life insurance won't pay out. Of course, if somebody's on life support and in a coma, the person's not technically deceased yet. So that would delay life insurance payout to that person. So yeah, sometimes that comes into play. But most of the times, I mean, it's better to not be guessing about who has your best interests in mind. That way you don't have to name
Yes,
your spouse as your power of attorney or your agent. You can name somebody else in
exactly. You
place
could
of
have
your
made it
spouse.
mom or dad. Yeah,
Yeah, exactly.
exactly. So, what are some of the common oversights that occur when people are going through some of these significant life changes around their estate planning?
So, common oversights, like I mentioned earlier, is not naming beneficiaries for your financial accounts, your investments, things like that, or leaving an old beneficiary listed on there. So, again, kind of getting back to that divorce question. When you get divorced, it's very important to go ahead and rename beneficiaries, especially if your ex spouse is in there somewhere, because whatever is listed on that beneficiary form is going to control even beyond what your will says. So, that's a very scary part. Many people think, oh, I'm just going to go update my will. Well, if you updated your will, make sure you update your beneficiary choices on those financial accounts, bank accounts, life insurance policies, retirement accounts, because that is going to override whatever will says. That's going to
Yes.
control. Yeah.
So, how can proactive estate planning provide some peace of mind when you're going through life transitions, some of which can be pretty traumatic?
Yeah, so the estate planning that we do here, and I know there's many law firms out there that do the similar work, but the one thing we take pride in is that we're very comprehensive, that the peace of mind planning starts with day one, just kind of going over all different kinds of scenarios. So one of the things that I like to do, instead of handing the potential client a list of questions, here, take this packet home, 10, 15 page packet, and fill it out and bring it back to me. I like to go over those questions and those potential scenarios during the sessions and getting to know each other, because a lot of times they will say, oh, I never thought about that. I never considered that situation. So one of the ones that is kind of very common is, again, the long-term versus short-term guardianship for children. Somebody might have a long-term guardian for a child, but not a short-term. And then if that long-term guardian is somewhere out in Europe or the Middle East, then it's going to take them days to come and pick up that child. So you don't want to necessarily have that kid exposed to strangers. That can be very traumatizing. Another oversight could be, again, like the titling of a house, leaving the spouse out of it by accident. I don't know what it is, but the closing agents, when you purchase a home, for whatever reason, I guess they don't pay attention to that, or the buyer or the purchaser of the home, they don't realize that their spouse is not on that deed. So I have a friend of mine recently that came to see me for a session and noticed that his wife is not on the deed of the house. So I explained to them, hey, if something happens, even though you guys are married, that house is going to go through probate, even though you both may be on the mortgage. But if it's not on the deed of the house, beware. You have to do something about that. And we can do some title work to add that person by way of quick claim deed. We can do that, or sometimes just put the house under the joint trust name. If they've created a trust, then you can go ahead and sidestep the quick claim process and just deed it to the trust itself, which will have your spouse included as the trustee along the lines there.
Exactly. And all the nuances that you intended.
Exactly. Yeah.
I think that brings us to the end of our topic today. Thank you so much for the wisdom that you shared.
No problem. No, it's a pleasure being on here and sharing this knowledge with others, because it's such an important topic in today's world that we live in. Things happen all the time. It's almost one of those things that people that are diagnosed with some kind of disease, they have notice as to how long they're going to live in most cases. And whereas everybody else thinks they have another day, or I have tomorrow to finish this, but that's not always the case.
Yeah, exactly. And thank you for listening to Wills, Estates, and What Comes Next. If you found today's episode helpful, be sure to subscribe, leave a review, and share it with someone you care about. For more information or to get in touch, visit CuzmarLaw.com, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.